Yeah, there. Okay. All right. Welcome. Welcome to the League of Women Voters of Wisconsin's webinar on Wisconsin constitutional amendments, their consequences, and best practices. We'll be exploring the unintended but real consequences of amending the state constitution with policies that do not advance constitutional governance principles. We'll be specifically discussing the negative consequences of four of the constitutional amendments that have passed in the last few years, and we'll be discussing issues regarding the legislature's intention of placing many more constitutional amendments on the ballot. I'm Joan Schwarz. I'm an attorney, a member of the board of directors for the Wisconsin League, and chair of the Impartial Justice Committee, which has done excellent planning and research for this webinar. A big thank you to Kathy Annan, Jane Benson, John Gowan, Myra Enlow, Cheryl Moranto, Janie Ribby, Mary Sussman, Mary Vogel, Carol Haig, Christy Schwan, and Penny Quake. Please provide your questions in the chat. There will be a question and answer period at the end of the presentation. And of course, as usual, a recording of tonight's webinar will be available on the Wisconsin League's website. We've also provided you with a bibliography of additional sources for your own reading. And also it will be on the League's YouTube site shortly. Okay, constitutions are more than just words on a page. They're living commitments. Constitutions are foundational to democracy, the rule of law, human rights, and good governance. Constitutional traditions are not merely a legal process, they're inherently social and political processes. By changing the system which underlines governance and rights, they can reframe the social contract between citizens and the state and reshape the ways in which individuals and groups access and exercise political power. Constitutional change processes have very high stakes. They can be easily captured by those who wish to entrench their own power. Amendments to the Constitution should strengthen our democracy, solve problems, and not be used for political gamemanship. Our lawmakers, regardless of political party, should always create bills through meaningful public debate and bipartisan collaboration. Constitutional amendments are not subject to the governor's veto and or Supreme Court review or modifications due to changing societal norms and conditions. For this reason, it's crucial to our well-being to make sure our Constitution and its amendment process focuses on governance and rights, not on political policies that the legislature should enact through legislation and statutes. Amending the Constitution is a serious step in Wisconsin's governance and should be limited to promoting good governance and rights in order to protect our constitutional stability. Unfortunately, each of the four amendments we will discuss tonight did pass, primarily because the wording of each of the amendments was framed to provide a yes vote from the public, and intentionally did not provide all the information about the potential negative consequences that would and have harmed some of our citizens. The four constitutional amendments that have passed: the bail amendment on the conditions of release before conviction and cash bail before conviction passed April 4th, 2023, with a 74% approval rating. Secondly, the amendment which banned private funding for election administration passed on April 2nd, 2024, with a 54.3% approval. The amendment that banned non-citizen voting in Wisconsin passed on November 4th, 2024, with 70.51% approval. And last, the April 25 election, the voter ID amendment passed with a 62.8%. Our first speaker tonight is attorney Doug Poland. Attorney Poland is the co-founder of Law Forward and is the full-time director of litigation. He has spent decades fighting for constitutional rights and democratic values in courtrooms across the state and at the U.S. Supreme Court. He played a key role in multiple successful challenges to Wisconsin's gerrymandered legislative maps, including serving on the legal team that took the pivotal Gill versus Whitford case to the United States Supreme Court. He also secured emergency relief for Wisconsin voters in Lewis v. Bosselman, extending mail-in ballot deadlines during the critical 2020 spring election amid novel pandemic challenges. Attorney Poland will discuss the negative consequences of the passage of the ban on private money for election administration. We will also discuss the impact that the passage of this amendment has had on 1,850 municipal and also the county clerks who manage our elections. Attorney Poland will then also discuss the negative consequences of the voter ID amendments. Welcome, Attorney Poland.
Well, thanks very much, Joan, and thanks so much for having me this evening. It's always a pleasure to jump on and address the viewership at audiences at League webinars because everyone is so knowledgeable, and it's always a lot of fun. So thanks very much. Well, as Joan mentioned, I am going to hit on two of the constitutional amendments that have passed over the course of the last couple of years. But before we do that, I am going to do a little bit of background, just a short background on the process of amending the Constitution itself. So as you may or may not know, Wisconsin adopted our Constitution in 1848 when we were granted statehood. We've never had any Constitution other than that first one, which was adopted 177 years ago. Some states have had multiple constitutional conventions and adopted different conventions, but we have our original Constitution that was adopted at that time. Although it is still in effect, it has been amended, and it has been amended 152 times since it was adopted. And although that might sound like a very high number to you, there are many other states that have adopted that have amended their constitutions many more times than that, hundreds of times. It has accelerated lately. The pace of constitutional amendments has accelerated in the last 5 or 6 years, but we really haven't amended our Constitution all that many times. But when you think about our state constitution, I think the questions that Joan had posed in the beginning make me wonder how many people in Wisconsin actually understand the process or processes by which we can amend our Constitution. And again, as Joan alluded in the beginning, how many understand how the questions that appear from time to time on our ballots when we go to vote are actually connected to constitutional amendments? So, a place where I'd like to start out is talking about direct democracy and how Wisconsin's Constitution compares to some other states. So, unlike some other states, Wisconsin citizens can't initiate an amendment to our Constitution. That stands in stark contrast to some other states like Michigan. And so, for example, in Michigan, citizens can petition to have a question put to the voters that would amend the Michigan Constitution. And they did exactly that in 2018. As Joan mentioned, I was involved in the Whitford versus Gill case. I tried the case to a federal court. We took it to the U.S. Supreme Court. We ended up losing the Supreme Court. We couldn't get the U.S. Supreme Court to recognize partisan gerrymandering as an actionable claim in federal court. And so we couldn't accomplish what we wanted to accomplish through the courts. Well, in Michigan, that wasn't the end of the road for them because they, through a citizen-led initiative, they actually got an amendment, a constitutional amendment on the ballot that required a nonpartisan redistricting commission to be put into place. We can't do that here. Okay, they did it in Michigan 2018. We can't do that here. We only have two ways that we can amend our state constitution. The first is through ballot questions, and that's what we're going to talk about tonight. And the second, and this is in our Constitution itself, it actually provides for how the Constitution could be amended. The other way we could potentially amend the Constitution would be by calling a constitutional convention. We've only had two constitutional conventions in our history. We had one in 1846, which did produce a constitution, but that first constitution wasn't approved by the voters, so it was never actually implemented. The only constitution we've ever had was the one that came from the second constitutional convention we had in 1847. That produced our constitution that we are still living under today. So the amendment procedure through ballot questions, that's what we're here to talk about tonight. That's the only one we've ever used. And that procedure to amend has to go through a number of steps. And so first, a majority of the Assembly and a majority of the Senate each must approve an amendment to the Constitution in a legislative session. Now, that is not subject to a veto by the governor. Joan mentioned that at the outset of the program. That's an incredibly important concept here, that it's a majority of the Senate, majority of the Assembly. They each have to approve an amendment, and it does not go to the governor for veto, unlike every other piece of legislation must go to the governor through the presentment clause of our state constitution. That's the first step. The second step is in a new legislative session following a general election. Again, the question will go to the Assembly and to the Senate, and a majority of them each must again approve the proposed amendment. So this would be a new session of the legislature. It would follow a year later. And then that vote, again, isn't subject to a gubernatorial veto. So once you have those first two steps accomplished, then the amendment will be submitted to the voters as a ballot question for approval by a majority of the voters and majority of the votes cast. And if the majority of the voters approves that ballot question, that effectuates the constitutional amendment. So it's that three-step process. So we know that a constitutional amendment is potentially coming a couple of years before it actually appears in our ballots, because it will appear before the Wisconsin State Senate and the Wisconsin State Assembly for them to adopt it. So that's the process. So now we're going to move on. We're going to talk about an amendment that was put to the voters in April of 2024, barring the use of private funds for election administration. And I want to start out by talking about the historical context for that ballot question. So in 2020, and remember, this is right as we were starting out with COVID, Facebook founder Mark Zuckerberg and his wife, who is quite a philanthropist, donated $350 million to an entity that they had formed called the Center for Tech and Civic Life, or CTCL. It's a nonprofit, and you can see there on the screen, that's how it describes itself. But basically, the idea is that these are election administration and data experts, and the work that they're doing is trying to inform voters, trying to put into place and fund mechanisms for voting that are going to engage voters, help them to turn out, help them to vote, and then also just to modernize our elections. So $350 million, and that was throughout the United States. That's the money that was available. Well, Wisconsin municipalities, towns, and counties took advantage of that money. Remember, again, it was COVID. And we were rapidly consolidating many polling places. We needed protective gear for poll workers, for election workers. There were a lot of additional complications that increased costs dramatically across the entire state. And so approximately $10 million of the funds that were made available through CTCL were used by more than 100 municipalities in 38 of Wisconsin's 72 counties. They had applied for the funding and they received the funding, and that covered the increased costs of administering the elections during the COVID-19 pandemic. That's a huge amount of money. That's a massive amount of money, and it was used throughout the state. So that was the historical context that happened. And the funds that were actually used throughout the state supported a number of different kinds of mechanisms and work that was done by election workers for poll worker recruitment, hazard pay and training, polling place rental, because we had to change polling places rapidly and find new ones, temporary staffing, drive-through voting. This is maybe triggering some memories that aren't such fond memories for folks. It was a really crazy time. But there was a lot of all these kinds of things you see on your screen, and then many more. That's what the funding went toward, helping us be able to hold those elections in April of 2020. And as I mentioned before, those counties that used CTCL funds, there were 38 across the state. And if you look at the names of these counties on your screen, Barron, Clark, Dodge, Jefferson, Kewaunee, Marinette, Polk, Washburn, yes, Milwaukee, Dane, and some other Democratic leaning counties did use funds. They did take funds, but so did many Republican leaning counties throughout the entire state of Wisconsin, including counties that voted for President Trump by overwhelming numbers, 60%, 65%, 70%. Those county clerks decided they could use the funds too to help administer their elections, and they did. They used them. That's the historical context, okay? So this is the text of the ballot question itself that appeared on ballots in April of 2024. Use, and this is all that it said. So all of those of you who went in to vote, this is exactly what you were reading. Use of private funds in election administration. Shall Section 7(1) of Article 3 of the Constitution be created to provide that private donations and grants may not be applied for, accepted, expended, or used in connection with the conduct of any primary election or referendum. That's all that it said. Okay, it didn't give the context. It didn't talk about the benefits. It didn't explain what the budget was that the legislature had appropriated for election administration. That's all that it said. Now, support for the proposed amendment was it came from a number of sources who are typically pro-voting organizations, Election Integrity for Wisconsin, Opportunity Solutions Project. I'm sorry. This is this is not support. These are the opponents. So I will have to fix that slide. Apologies for that. These are the opponents. These are the ones who did not endorse the proposed amendment. Election Integrity for Wisconsin, Opportunity Solutions Project, Wisconsin Institute for Law and Liberty, and the Wisconsin Voter Alliance. And I've highlighted the language. There was a statement that was made by the policy director for the Wisconsin Institute of Law and Liberty. And basically the argument that was made is that Mark Zuckerberg, this is what they said, Mark Zuckerberg is a Democratic leaning and supporting person that the money that was made available went disproportionately to Democratic leaning communities, and that if a donor with right-leaning inclinations were to direct resources exclusively toward Republican leaning areas, well, certainly nobody would be happy with that as well. Well, of course, that misstates exactly what happened in April of 2020 with the money that CTCL made available, as I just showed. It went across the state. It was bipartisan, and it was used by clerks in counties that were blue and red alike. So that was actually those were the that was not the support. That was the opponents of the proposed amendment. And I got this backwards too, so I'm sorry. The proposed amendment was, no, I'm sorry. I had that right. I've got it backwards. This was the support for the proposed amendment. These are the people who wanted to put into place the constitutional amendment. So the people who opposed the proposed amendment, they didn't want this to go into the state constitution, were the organizations that you typically will see, the pro-voter organizations. These are the ones that want to make voting widely available, want to try to make sure that elections are held in such a way that they can maximize participation. And so it was opposed by All Voting is Local, Wisconsin Conservation Voters, Wisconsin Democracy Campaign. And of course, the League of Women Voters, they urged a no vote for a number of reasons. And I've got some of those up here. Reduces the options for municipal governments that are looking for outside funding to be able to fund their elections. It would have a negative impact on the voter experience, could lead to long wait times, long lines, long wait times, consolidated polling places, all the kinds of things, or many of them, that we saw in that April 2020 election. And also just a fundamental principle that this kind of change should not be in the Constitution. This is the kind of a change that should be in legislation that gets passed, with the governor able to veto it if the governor doesn't think it's appropriate, and that could get changed by a subsequent legislature. So those are the reasons why the league was urging voters to vote no. As was mentioned at the very outset, Joan mentioned the proposed amendment nevertheless passed by a vote of 54% approximately who were in favor of the amendment, and 45% were voted no on it. And so it did pass, it did go into law, and as a result, that is what we have for law. I'm going to turn it over now to Joan to talk about a survey that the league conducted of clerks after the amendment became effective.
Thank you. Thank you, Doug. Hey, this summer, Jane Benson of the League of Women Voters of Wisconsin, our ad hoc committee, Impartial Justice, surveyed all 1,850 municipal clerks and county clerks. We received survey results from 203 municipal clerks representing 218 municipalities and 7 county clerks. Let me just get rid of that little thing. Okay. So I'm going to give you some flavor of what we gleaned from the survey. First, clerks must fully fund elections, but end up using general budget money from transportation, often from the road budget, and property tax money to make up for inadequate state election funding. Some clerks noted that the state legislature is not making elections a priority and funding them directly. Other observations are that they need the state to provide more money for all election processes changes the legislature is making so as to enact these changes, such as for printing ballots, postage, programming voting machines, swings in election budget needs, depending on whether it's a presidential election or not. Also, they noted there is no line funding elections in the shared revenue budget bill. Rural clerks were especially concerned about being able to fund elections well without the option of using private money sometimes. Their budgets tend to be very small, and they don't have a lot of options for funding elections other than drawing funds from, once again, the general budget or the roads account. They said they needed grants to help with purchasing badge books, upgrading their laptops, converting to .gov email addresses for more security. Some suburban clerks said they were facing hardship because of the additional postage for absentee ballots, not being able to purchase new voting machines, and the rising cost of placing election notices in local newspapers. The major budget pressures that came through all of the responses by the municipal clerks, covering the cost of absentee voting, not wanting to increase property taxes, staying current with updates on new election technology, working within the state mandated levy limits, paying election officials, not receiving enough revenue money, sharing dollars from the state, and increased training costs. They used the private funds, and some of what Doug already spoke about. These were some of the things that they used the private funds: a new laptop computer specifically for election work, purchasing supplies, voting machine tape rolls, magnifiers, security tapes, security cabinets, election security storage, new signage displays, advertising for election officials and providing general knowledge, new voting booths, ADA compliant booth, ballot boxes, voting machines, express vote machines, election equipment, secure drop boxes, and increased costs in absentee voting. And of course, all the protective supplies, mask barriers, gloves, and sanitizing, which were needed for the election. I'm going to give you a couple of statements so you get the flavor of exactly the frustration. Quote, the ban on private funding for election administration was yet another solution in search of a problem. It would be nice if the legislature asked clerks what their real issues are instead of getting these ridiculous ideas in their heads. Another comment. It would have been nice for legislators who supported this constitutional amendment to also have made state budget allocations to fund elections instead of pawning that off on counties and municipalities as they always have. It's fairly hypocritical to take away an avenue of funding away from municipalities and not replace it with state funding, especially when all the legislators' silly constitutional amendments lately only add to the cost of printing ballots and programming voting machines. A third comment. I do not think in concept, if the state is going to prohibit private election funding, it should make a more concerted effort to fund elections. It provides general funding through shared revenue, but that doesn't really take into account providing additional funding when additional funding is needed to administer elections. Costs to the municipality greatly rise in even years when there are 4 elections, and especially during years with the presidential election. This would be a great topic for the state to discuss, how we could support municipalities as it relates to the cost of elections. Another comment, referendum questions need to be clear and not confusing to people when they vote. In some cases, a no could mean a yes, and that was not the intent of the voter. News media is getting better about explaining a referendum question, but once at the polls, if they don't understand it, they tend to leave it blank, sadly. And lastly, the wording of the state amendments is confusing and unclear to most voters. It's frustrating that most voters don't understand many of the issues that are put on the ballot. Okay, Doug.
Well, thanks, Joan. And to close out the discussion of this amendment, all of those things that Joan just talked about, that the league heard from the clerks throughout the state in the survey, this really reinforces and drives that home. As I noted before, $10 million in support was made available through CTCL to clerks throughout the state in 2020. Well, the legislature, despite taking that away now, taking that $10 million or any private support away, they should have gone back in, as some of those clerks said, they should fill that gap. It's not like the atmosphere that we have now is any less challenging. It's much more challenging. We have we have a lot of threats that have been made. We've got an atmosphere of hostility, of violent rhetoric, and we're going to need to take ever more steps to protect our clerks, our election officials, make sure that we're actually ensuring that people feel safe when they go to vote. And yet, the legislature has essentially not increased the funds that are available for administering elections in our 2025 to 2027 budget. So they took away $10 million in support and they basically gave no more back. And it gets worse. And the reason it gets worse is that the federal government, which had provided a lot of support for state election administration, has dramatically decreased it. Congress appropriated only $15 million in March for election security grants. It's a 73% drop from 2024. And CISA, which handles election security nationally, they've cut funding as well for sharing and analysis, and it's essentially not operational. So we're not going to be sharing government information between the federal government and the state government when it comes to in many election administration issues. And the result of this is that states have to shoulder more of the costs for election administration than in recent years. And if the state won't do it, then it falls to the county and to the local level. So with that, let me move on to the next amendment that I'm going to address, and that's the April 2025 amendment, just this past April, requiring voters to present photographic identification to vote. And again, I would like to start with just sort of a historical background that before 2011, Wisconsin was actually one of the most pro-voter participation states in the country. We required voters to furnish proof of identification only if it applied when you had to prove your residence. Otherwise, you didn't have to show your photo ID to vote. But in 2011, Wisconsin enacted 2011 Wisconsin Act 423, which has been widely reported as and is one of the most restrictive voter IDs laws in the United States. I put the statutory reference down there where it can be found in the statutes now, section 5.02 sub 6M. That is the statute that sets forth the allowable forms of voter ID, and you can see them all. You can see them up there. So there are a number that are prescribed, but it isn't exactly a bevy of options that everyone can take advantage of. There were a number of court challenges right off the bat when the statute was passed in 2011. Some were in state courts and some were in the federal courts. And there was a very lengthy litigation process that they went through. The state spent a lot of money litigating this, as did private individuals and groups. But the end result was that the voter ID laws were largely upheld. There were only some provisions pertaining to forms of student identification that the federal courts ultimately held could not be enforced. The final major decision addressing the voter ID statute came from the Seventh Circuit Court of Appeals. That's our federal Court of Appeals located in Chicago. That came in June 2020. It was just a few months before that incredibly consequential election in November of 2020. But the upshot of it was that by that time, the voter ID statute enacted in 2011, that it's essentially been in full effect since the fall of 2020. So the text of the ballot
could you put your slides up?
They should be displayed right now if they are not. I'm sorry.
They're not.
Okay, let me make sure they are.
Didn't
Thank
mean
you,
to
Joan,
interrupt.
for putting in.
Thank you. That's where you are right now. Thank
You
you.
can see them now? All right. Well, my apologies, everyone. I thought that I had them up. So the text of the ballot question itself, this is what appeared on our ballots this past April. Photographic identification for voting. Shall Section 1M of Article 3 of the Constitution be created? So you're not amending a provision, now you're creating a new constitutional provision to require that voters present valid photographic identification, verifying their identity in order to vote in any election, subject to exceptions which may be established by law. So that was the text of the question. Again, none of the context was there. And one of the pieces of the context that was incredibly important that was reported by some but wasn't really made known by the proponents of the amendment is that everything that appears in this constitutional amendment was essentially already law that was on the books in Wisconsin. So they conceded, the proponents of the amendment, the people who wanted a yes vote, they conceded that it really added nothing to the law. That this photographic ID, voter ID law that had been passed in 2011, it was already on the books. The constitutional amendment did nothing more than was already there. But this was really what they were going for. The effect of enshrining those provisions in the state constitution meant that by including voter ID in the state constitution, that means that courts can't hold that applying those constitutional provisions violates the Wisconsin Constitution because it's part of it. So it's a way of taking a tool away from courts that they might be able to use in any individual situation to be able to find that an individual voter's constitutional rights were violated, because now those constitutional rights are circumscribed by the voter ID constitutional amendment. It's in the Constitution. And the second reason that the proponents wanted to include the voter ID provisions in the state constitution is to prevent the legislature from changing the laws in the future. If the voter ID statutes themselves had just remained statutes and not gone into the Constitution, that would mean that if and when there's a change in the, not necessarily, that wouldn't have to be the partisan makeup of the legislature, but most likely would be. But a later legislature could go back and it could just take away the voter ID statute. That could have happened. But now that it's in the Constitution, a legislature can't do that. The only way to change the constitutional provisions now that require identification by voters is to amend the Constitution again. Now, there were opponents of the proposed amendment, and there were a number of them that included League of Women Voters and many of the other pro-voter groups. And one of the main reasons that they did that, and I'd like to focus on this in a minute, is that there was a study that was published in 2019 by University of Wisconsin political science professor Ken Mayer, who's testified widely throughout Wisconsin in a number of different cases, including partisan gerrymandering and other election kinds of cases. He and one of his PhD candidate students presented results of research they had done on the impact of Wisconsin's voter ID laws on voting in the 2016 election. And they found a couple of very important impacts that the voter ID law had on voting. They found a direct effect that the laws prevented otherwise qualified voters from voting because of bureaucratic obstacles that were imposed by law. Maybe the voters lacked and can't obtain the required identification, or they're told at the polling place that their ID is insufficient. And another is an indirect effect from confusion caused by technical and administrative details of the law that aren't understood, that deter people from voting, even if they possess the required ID. They mistakenly believe they do not. I'm sorry, I had neglected to put up the slide that shows in the statute these are the allowable forms of voter ID, and we can all look at those. But it kind of takes a lawyer, doesn't it, to look at those and figure out what is actually an acceptable form of ID. For many of us who vote regularly, we could probably figure it out. But there is a very large percentage of the voting population, as Professor Mayer found, that a portion of the population that doesn't know that and can't figure it out. They also found that 10% of non-voting registrants were deterred from voting by the voter ID law, and 6% of non-voters were prevented from voting. So here, in contrast to our state's long history of encouraging voter participation, making voting easier and encouraging participation, the voter ID statutes did exactly the opposite. And because this amendment mirrors those statutes, it's expected to do the same. And of course, as is so often happens with these laws that restrict voting, the burden falls most heavily among individuals who are Black, earn lower incomes, or have less formal education. The authors summed up their study, as I note here, by saying that the number of people affected by voter ID requirements exceeds by orders of magnitude the number of cases of voter impersonation ID laws are purportedly designed to prevent. It was a solution in search of a problem. And the upshot of it is that because of the event of the amendment now, there are potentially tens or even hundreds of thousands of Wisconsin voters who will be prevented or deterred from voting by the ID requirements, and they will have no recourse in our courts, and that burden will fall most highly on, as Professor Mayer found, voters who are Black, earn lower incomes, and have less formal education. I guess this slide should have gone earlier. These are some of the opponents of the proposed amendment. As I noted, the League, of course, was in there, as are many of the other collaborating organizations that are often on the pro-voter side. So the proposed amendment passed. As Joe noted, it was a very high percentage, almost 63%. Only 37% voted no. And so as of April 1st, 2025, voter ID is enshrined in our state constitution. And that does it for me.
Thank you very much, Doug. We really appreciate it. Okay, our second speaker is Attorney Jasleen Singh. She is a senior counsel and manager in the Brennan Center's Democracy Program, where she focuses on voting rights and elections. She previously served as the Deputy Attorney General in the Civil Rights Enforcement Section of the California Attorney General's Office, where she worked on immigration and administrative law issues. Attorney Singh will discuss the negative consequences of the passage of the ban on non-citizen voting in Wisconsin. Welcome, Jasleen.
Okay, I've unmuted myself.
Yes. Okay. Hi.
Great. Awesome. Hello. And you can see my screen?
Yes.
Okay, great. Thank you so much, and thank you for having me this evening. I am Jasleen Singh, and I am at the Brennan Center for Justice. Just by way of background, the Brennan Center is an advocacy organization that's part think tank, part law firm, part communications hub. And I'm here with all of you today because I wanted to offer some big picture context for the constitutional amendment that voters passed last November, that has to do with citizenship and voting. To provide a bit of a roadmap, I'll first talk about last year's ballot initiative, and then talk about why the myth of non-citizen voting is indeed a myth. And I'll share some research about how some of our research over time that's shown time and time again that non-citizen voting is vanishingly rare, that it's already illegal for non-citizens to vote in federal elections, and the negative consequences that this conspiracy theory that non-citizens are on our voter rolls is having or can have on the right to vote. And let's get started. So just toggling in between a little. All right. So last year, Wisconsin voters said yes to a ballot initiative that stated, this was the question: shall Section 1 of Article 3 of the Constitution, which deals with suffrage, be amended to provide that only a United States citizen aged 18 or older who resides in an election district may vote in an election for national, state, or local office, or at a statewide or local referendum? And so I think Doug just pointed this out about the voter ID provision or the voter ID ballot initiative. But I think what a voter could take away from this is that, oh, there's nothing about citizenship in the Wisconsin Constitution already. Not the case. In actuality, a yes vote changed the Constitution from stating every United States citizen age 18 and older, et cetera, and it changed it to only a United States citizen age 18 or older, et cetera, et cetera, et cetera. So it's really just a one-word change, but that one-word change comes with sort of very heavy context. And the net effect, though, is absolutely nothing. Only citizens were eligible to vote and voted in Wisconsin before, and now only citizens vote and are eligible to vote in Wisconsin now. So the actual effect of the amendment is nil. But I think the reason that it became an amendment, that the legislature passed it to put to voters, is sort of within this context where we're seeing a lot of lies being spewed about citizenship and voting, and people who aren't citizens on our voter rolls being able to vote, being registered to vote. And what's frustrating about this initiative and its passage is that this was the legislature's second attempt to codify this lie. In 2022, the Wisconsin governor stopped two non-citizen voting related bills from being enacted, citing that, quote, there is no evidence of non-citizens voting in this state, and the bills would perpetuate false narratives about Wisconsin's elections. And so to sort of get into a little bit of the what's already in place, both in Wisconsin and really in every state, what's already in place to ensure that only citizens are registering to vote and voting. States have multiple systems in place to ensure that only citizens are voting. And so under federal law dictates that only U.S. citizens can vote in federal elections. To register to vote, you must swear you're a citizen under penalty of perjury. So under the penalty of potential criminal prosecution. And for people who are not citizens who are looking at that box, penalties include possible deportation. It's far more than just a jail time or fines within the country. And under federal law, states are also required to conduct regular voter list maintenance to remove ineligible voters from the rolls. So it's already a crime many times over for non-citizens to vote in state and federal elections. It's also extremely risky for non-citizens to cast ballots. So think about it this way. If you're an undocumented person or a person with a green card and you're in this country, would you risk everything, your freedom, your life in the United States, your ability to be near family, just to cast a single ballot in a single election? It just doesn't make sense because the risk is far too great. And the reality is states already do a really great job of making sure that non-citizens are not registering to vote, are not voting. And one example of this that actually happened, I think, last week, the Secretary of State of Louisiana took a look at all the voter rolls dating back to the 1980s. And from all of those millions of votes cast, at least 74 million votes were cast from 1980 until now. There were 79 instances where it was possible that a non-citizen cast a ballot. That is 1 in a million in perspective. And so that was a sort of a tidbit that came out recently, but in and of it, but every study that's looked at this and has looked at the possibility of non-citizens voting has come up the same, that it's rare, it's increasingly rare, and it's not something that plagues our elections. And to that point, we know these checks are working that are in the states because we know that non-citizen voting is not a widespread phenomenon. So we have the example of the Louisiana Secretary of State's investigation from last week. The Brennan Center for Justice has also done research on this topic. And we did a report that came out based on the 2016 election, where we found that across 42 jurisdictions, election officials who oversaw the tabulation of 23 million votes in the 2016 election referred only about 30 instances of suspected non-citizen voting for further investigation or prosecution. That also is a really, really, really tiny amount. In 2020, the Cato Institute assessed and debunked a 2015 study claiming that high percentages of non-citizens are voting. And the Cato Institute concluded, which is a more conservative-leaning organization, concluded non-citizens don't illegally vote in detectable numbers. And state-led investigations like the one that Louisiana did, but state-led investigations on both sides by Republicans, by Democratic officials, have found almost no instances of non-citizen voting. Similarly with news organizations that have taken upon themselves to do this kind of research. So it's just not a phenomenon, and yet it's something that drove the Wisconsin legislature to essentially put this on the ballot. And I think what I wanted to do is also give some context for, I think the focus on non-citizen voting has sort of flourished in the last few years, and certainly in this year. And so we see that from a lot of different angles, and we see that most significantly and differently. And what's novel about this year is that we really see this lie sort of being spewed or being acted upon by the federal government. And so generally what we've seen in years past is we see state legislatures acting on this, vigilantes, and certainly the topic of a lot of messaging. But the federal government this year has really been sort of espousing or taking actions pursuant to this lie that non-citizens are voting, and Congress as well. So one example is the executive order. There was an executive order that this administration that Trump issued in March of this year, and that order purports to require citizens it purports to require and the Election Assistance Commission, which is an independent bipartisan agency, to change the federal voter registration form, which is used widely across the nation. And the order purports to direct that agency to require citizens to produce a passport or similar document to register to vote when using that federal voter registration form. And I think what's really dangerous about this is the fact that if this right now, the Brennan Center and many other organizations have challenged this provision in court, and for this time being, it is preliminarily enjoined, so it's stopped for the time being. But should something like this, should this go into effect at any point, or the requirement for documenting proof of citizenship go into effect, and certain states have also passed this themselves, but this would be at the federal level, it stands to potentially disenfranchise millions of voters. Brennan Center research shows that 21 million people do not have ready access to a passport, a birth certificate, a naturalization document. And so if showing that kind of document, showing a passport, which only about 50% of folks have in the country, becomes a requirement of registration, imagine how many folks could be disenfranchised from that. Then we have the SAVE Act. Similar to what the executive order purported to do, the SAVE Act would have added a documentary proof of citizenship requirement to vote. It has passed the House, but fortunately it's been stalled in the Senate, and there hasn't been movement on it since I think about April. But effectively would have done the same thing nationwide as what the executive order purported to do. We also have seen an uptick in election task forces. So there's a new task force at the DOJ. There's a task force created by the U.S. Attorney's Office in Washington, D.C., and another elections task force created by the New Jersey U.S. Attorney. And these task forces, what they do is they establish a federal law enforcement approach to elections focused on targeting voters, election officials, perceived political adversaries, and they devote resources to search for supposed widespread fraud, including non-citizen voting, and which we know does not exist. And so it's a reallocation of federal resources towards this lie of non-citizen voting, among other things. And then we also this year have seen we've seen a focus on what's called the SAVE program, different from the SAVE Act. The acronyms are a lot, but the SAVE program is basically a federal search engine. It's a program that was designed to help states verify the citizenship and immigration status of people applying for government benefits like SNAP or TANF. And some states and local governments use this to verify citizenship status for voterless maintenance purposes. This year, though, it's a program run by the DHS. This year, the DHS, along with DOJ, announced an overhaul of the program. And it's been dramatically expanded, and the changes, including being able to input bulk inquiries, so a state's entire voter file can be input into the system, all at once. Previously, only one by one could inquiries be made. So there's bulk inquiries that are possible. And then second, the program now allows a state to search with a social security number. Previously, you needed to have a DHS issued identification number. So it's normally an A number. To make a search or to conduct a search through the SAVE program. Now it's opened it up to social security number. So name, birth date, social security number. And the program now has access to the SAVE database. And so the issues with this is the SAVE program to begin with was often based on flawed or outdated data, and the new access to the Social Security database does not solve that problem. The SAFE program, even with the addition of the Social Security data, is not a citizenship database. And so we still have the expanded program, the overhaul of the program, it sort of exacerbates and amplifies existing problems that the search engine already had. And I think with that, we need to be looking out for example, widespread claims of non-citizen voting based on a SAVE search alone. We need to be looking out for potential voter purges based on the SAVE program. Without proper checks in place and without election officials sort of doing the due diligence of following up if someone doesn't come up with a result in that program, that could stand to disenfranchise folks. And at the beginning of this year, I think maybe about 12 or 13 entities, about 10 of which were states, had agreements to use that program. Now that number has shot up to about 50 plus entities. And so a lot more counties, a lot more states are now using that program for voter list maintenance purposes. And the results of that is more to come. But it's sort of, I wanted to point that out along with a lot of the other things I pointed out, because there really has been a focused, there's been a focus on this lie about non-citizens and voting recently. And then, of course, lastly, we've seen a lot of ICE activity. It's sort of at a fever pitch, and we see that the agency has been emboldened with significant new funding. There's clearly a focus on immigration in this administration. And I think there is the possibility that we should take seriously that ICE or federal agents could be deployed in and around elections. We're seeing, right this year, California is having a special election this November. And at the announcement that the governor held for that special election, masked federal agents were out there in full force attending that announcement. And so that indicates that it is possible that ICE, other federal agents, may be deployed around elections, and state officials sort of need to be prepared for that. And then I'll just end with sort of the effects that this lie can have on folks. This is a multifaceted effort to push this lie of non-citizen voting, or actions we're seeing Congress or the federal government take based upon this lie about non-citizen voting. But it can have a chilling effect, an intimidating effect on people, on eligible voters. It can also really cause confusion for voters. And I think ultimately what it can do is sow doubt in how our elections are running, sow doubt in how our election officials are upholding our elections and have been able to conduct secure, smooth, lack of eventful elections in the last few years, in the face of the pandemic, in the face of a lot of misinformation about voter fraud or mail voting. Our election officials have stood strong and have been really resilient. But when we have a federal government or attempts by state legislatures to act upon the lie of non-citizen voting, that ultimately sows doubt in our elections themselves. And then, as I talked about earlier, it also stands to it risks disenfranchising millions of voters as well. So at the end of the day, only citizens are voting in our elections. Wisconsin's ballot initiative does not change that fact. It was just fueled by this non-citizen lie, and it's because only citizens can vote. I'm going to end my presentation there and reserve time for follow-ups at the end. Thank you.
Thank you. Thank you very much, Jasleen. Okay, our next speaker is Margo Kirchner. She's the executive director of Wisconsin Justice Initiative. She previously held the roles of development director and general counsel of Wisconsin Justice Initiative. Prior to joining Justice Initiative, she was a career law clerk in the federal courts for judges in the Eastern District of Wisconsin for more than 20 years and at the Seventh Circuit Court of Appeals. She will discuss the problematic issues with the bail amendment as it was worded on our ballots. And following her, then Dennis Franklin will explain some of the actual consequences. We will finish with Margo coming back and explaining best practices that we all need to follow when we see more constitutional amendments on our ballot. So Margo, would you please begin? Thank you.
Sorry about that. I forgot to unmute at the start. Can you see my slides?
Hi. Yes.
Okay, great. So back in April 2023, voters saw two separate ballot questions. They both relate to the same provision of the Constitution. So it's a provision, there's a separate provision that allows but does not require circuit courts to keep someone in custody for very severe felonies such as murder, sexual assault, where the punishment is over 20 years. And so that's the provision about keeping somebody in custody. These two amendments affected the provision that talks about release and bail. So the first one is just a change of one word at the start with a little extra highlighted in yellow here. And it changed that the provision that all persons before conviction shall be eligible for release, so that's a guarantee, that you're eligible for release under reasonable conditions designed to assure their appearance in court, protect members of the community from serious bodily harm, is how it used to read. And the changed it to be serious harm as defined by the legislature by law, or to prevent the intimidation of witnesses. And we'll get to the second part of this provision for the Second Amendment. So the First Amendment took out that word bodily and said it's now serious harm as defined by the legislature. Voters were not told that that was really the change, and I'll get to that in a second. But the prior provision allowed release with conditions. So this is the items that the judge can put on the defendant to make them check in with a pretrial officer, not drink alcohol, absolute sobriety, not contact certain alleged victims. So the judge can put a variety of conditions on someone, but those conditions used to be only for assuring appearance in court, preventing intimidation of witnesses, and protecting members of the community from serious bodily harm. Serious bodily harm meant very serious bodily harm, such as risk of death, permanent disfigurement, protracted loss or impairment of bodily function. So very, very severe bodily injury. The change from serious bodily injury to serious bodily harm to serious harm, as defined by the legislature, opened up a whole host of new things that could be considered for purposes of putting conditions on release. So as defined by the legislature passed 2023 Wisconsin Act 3 to define what serious harm meant for this amendment. And it includes damage to property over $2,500, economic loss, that means business loss, lost profits over $2,500, and then really any personal physical pain or injury, illness, or impairment. So it went from being very, very serious to really being economic. Property damage, if you think of damage to property over $2,500, that could be a very vast array of activity. So So voters were not told about the change from serious bodily harm to serious harm. They were just asked whether the Constitution should be amended to allow a court to impose on an accused person conditions that are designed to protect the community from serious harm. It sounds very reasonable. It failed to tell the voters that you were actually really very much loosening up all of the conditions that a judge can put on someone who is accused, not convicted of crime. This is for pretrial detention when someone is supposed to be presumed innocent. And there's a Supreme Court case from 1987, Salerno versus United States, that says that pretrial detention should be the exception, not the norm. And this type of amendment moves towards that becoming the norm of keeping people having conditions. And once they violate the conditions, they can be taken into custody before even being convicted of a crime. The Second Amendment addresses that second part of the provision that I had up before. So you can see here, the serious bodily harm was changed from one ballot question. The second ballot question added all of the part in yellow, which is extensive. But the main change here is that monetary conditions of release, so bail, monetary conditions are bail, and bail was only allowed under the Constitution previously to ensure someone's appearance at court. So it was added that in addition to assuring appearance in court, in the case of a violent crime, that the judge can take into account the totality of circumstances surrounding the case, the defendant, risk of appearance in court, risk to potential other people, anything that the judge really thinks is pertinent can now be taken into account in the process of setting a monetary amount for that person to pay to be released. And of course, if you think that through, the result is not necessarily that only people who are risky for the public are kept in. The people who are kept in custody are the people who cannot afford to pay the bail that is set. So people with the money, regardless of what the risk factors are, and regardless of how high the bail amount is, the people who can pay will get out, and the people who cannot pay will not get out. So as I said before, the prior provision was just to ensure appearance in court, and now a person accused of a violent crime, as defined by the legislature, has bail set based on the totality of the circumstances. What it really means is that now 80 crimes, Wisconsin 2023 Act 3, the legislature defined what violent crimes mean, and they include any one of 80 different offenses. So now for any of those offenses, the judge can set monetary bail. Those violent crimes include mistreatment of animals, leaving a loaded firearm within access of a child, violation of a harassment temporary restraining order, even if no physical harm has occurred. And then there are, of course, some very, very serious violent crimes. I don't deny that at all, but there are some, such as mistreating animals, that, does that allow the judge to set a very, very high bail? One of the points here is that the standard for the amount of bail that's set, if it's set to ensure somebody appears in court, it's supposed to be the lowest amount that would ensure that appearance in court. But if bail is imposed on a defendant accused of a violent crime, the only protection on that is there's a constitutional provision saying that bail cannot be excessive. So the question is, what is excessive? And you may have different judges setting different amounts based on what those judges believe excessive might be. So you will have most likely very much higher bail amounts being set than you did previously. The question for this one was a little bit more clear than the first question. It did fail to tell voters that bail was previously only to ensure a court appearance, and that this was potentially expanding, the application of high amounts of bail, as opposed to just an amount that would deter somebody from losing that money by not showing up. And the bottom line is that more conditions, after these amendments, more conditions can be imposed on someone, which means more likelihood of someone violating some condition, sending them into pretrial custody, again, before being convicted of anything. And it's very likely that the imposition of bail without much restriction on the amount when a violent felony is charged means more people will stay in custody because they cannot afford to pay. And we know from various studies that the burdens of this fall much more on low income and minority populations who are more likely to have bail imposed and more likely not to be able to pay it. And I'm going to turn it over to Dennis now to talk about the effects of the pretrial detention and why we really need to care about people sitting in jail prior to their cases being tried, and the effects it can have on someone accused of crime, not convicted of crime.
Thank you very much, Margo. And as referenced, Dennis Franklin, Senior, is the Interim Associate Director of EXPO, Ex-Incarcerated People Organizing. As Interim Director, he promotes second chances informed by his incarceration experience. Pursuing a human services degree at Madison College, Mr. Franklin empowers others and confronts systematic injustice. Dennis has successfully impacted Wisconsin state and federal court cases, including a Wisconsin Supreme Court victory limiting enhanced federal sentences. With extensive knowledge, Dennis supports individuals at EXPO and pushes for change in the system. Now, I am going to comment that we are going to be running later than 8:30, so we're going to hear Dennis's comment, but I do want to make certain that Margo is able to explain best practices that are going to be really important for constitutional amendments that will be coming up. So keep in mind that in November 2026, there will be amendment. It's already gone through the second legislature section, which will prevent the state from closing religious entities if there's another pandemic or problem worldwide. It was health problem in Wisconsin. So Dennis, I'm going to ask you if you can just abbreviate yours a little bit so we don't run too long over into the question. But I'm also going to ask if you would like your questions answered, and we're running over 8:30. Please stay for your questions to be answered. And I'm sorry that we will be running over. Okay, thank you, Dennis.
You're welcome. I was already on that. That's why I was kind of breezing through my slides so I can, go with things that are most pertinent. But, as John said, my name is Dennis Franklin. I am Associate Director of EXPO, Ex-Incarcerated People Organizing. And a lot of the stuff that's in my slides, Margo has already touched on, so I'm just going to move it along. One of the points that I have up on the screen right now is the racial disparities when it comes to individuals who enter pretrial detention. Nearly 7 in 10 pretrial detainees were people of color. Defendants of color are 10 to 25% more likely than white defendants to be detained pretrial or have to pay, money for bail. Young Black men are 50% more likely to be detained or pretrial than white defendants. Defendants of color may receive an enormous amount of bail that is twice as high as our counterparts, and the median bond amounts often $10,000 or higher. This pretrial detention thing is something that's really dear to me because I'm a person who has actually been held in pretrial detention and has suffered some of these financial consequences where I was held in pretrial detention and I was held there for 8 days. And I can remember contacting my job, and my job was saying that if you can get out in 7 days, we'll be able to keep your job for you. I was able to get out in 8 days. And that 8 days turned my life upside down. Um, I lost my job, of course. I lost my house. I lost my transportation. It just turned everything just upside down. And then we're going over here to the financial consequences. Individuals who enter pretrial detention are more likely to come from poor, marginalized communities, um, unable to make the bail before release, and less likely to have formal employment or come from stable family and backgrounds. Um, cannot work to earn the income while incarcerated. Cannot work. I mean, frequently lose their jobs. As I was just speaking on something that happened to me, long-term unemployment after release. Um, Risk of losing your housing, your apartment, your car, more likely to encounter destitute, including, hunger and homelessness. So that was always something that was at the forefront for individuals that um, I was able to encounter or that I worked with. And like I said, including myself. Um, so I'm going to go to the work part of this right now. Individuals who enter pretrial detention has a significant decrease in employment rates. Individuals held at pretrial had a 9.4% lower probability of being employed 3 or 4 years after bail hearings compared with similar situated individuals released to pretrial. Pretrial detention could lead to a lifetime income loss around $29,000 on average, even with no conviction. And I'm just going to just move this along a little bit, and that's just compared to similar individuals in pretrial and those who were detained. So, man, the financial impact, the work impact, the housing, so much stuff can be turned upside down for an individual who hasn't even been convicted of a crime. We're just in the pre-trial phases of haven't even been convicted of a crime, and to have to go through uh, some of the things that you will eventually go through of not being able to make bail, to have something like that in the Constitution, to me, is just absurd. But like I said, we go over to the housing and the transportation. Individuals who enter pretrial detention have a 12% likelihood of becoming unhoused following an arrest, compared to about 2 to 3% among non-detained individuals. A 40% increase in the risk of becoming unhoused. You are more likely to experience housing instability, such as being able to pay your rent, your utilities, and possibly being evicted. Have a higher chance of losing the vehicles, which can be a barrier to employment. You're missing your car payments. Vehicle probably got towed, is in the impound. It just creates so much hardship for an individual. And then we're going to speed up to the criminal justice process. Individuals held in pretrial detention. Individuals held in the pretrial detention may not be prepared for their experiences with the legal system. I can remember being in that situation, having individuals who had absolutely no clue about what was going on or what could possibly go on while going through the whole pretrial, not even having an attorney to be able to have these things explained to them correctly. So that puts you in a position where you're more likely to just want to plea out. I just need to get out of here. I need to just take this plea, and I just need to get home, or I need to just get wherever I'm going because my life is stagnant. And it does appear a lot to just have you pressured. You feel like you have to do something just to get out of here. So oftentimes, especially in marginalized communities, that will come out in the form of just taking a plea so you can just get out, and oftentimes taking probation and withheld sentences and all of that stuff. And now you're on that hamster wheel. And then you may be incarcerated and not ultimately convicted, yet still face consequences of missing work and being able to pay your bills and things like that. formerly detained individuals, jailing a person based on trial which is associated with an increased likelihood of arrest, already more challenging than formerly incarcerated individuals to get a job, risk of losing economic process of the job, more likely to receive a longer sentence if they have spent time in pretrial detention. Those who have not been previously detained are not less likely to appear for court than those who have been detained in pretrial. Effects on the family in 2018, over half of the people held in pretrial detention were the main caretakers of the minor children. And that is so true. Like I said, being a person who have experienced it, you have individuals who are taking care of their children. Some people are taking care of parents, aging relatives, and that definitely puts you in a position where you have to get out. You want to do what you need to get out because you do not want to be the person who is the primary caretaker and you are detained. In a 2016 study, 4.5% of parents reported pretrial detention changed their child living situation. 16.5% were unsure of how their child or children would be impacted. Children of pretrial detainees are more likely to drop out of school, develop antisocial behaviors, and engage in criminal activity. So I just kind of did a quick, I just wanted to run through and just give you guys a quick overview of what it feels like to be in a situation where you haven't even been convicted of a crime and you can lose everything. And this is a topic that's very deep to me. It's very personal because I was once that individual. Thank you.
Thank you so much, Dennis. Really gives us the real world consequences of the bail amendment. We do appreciate it. Okay, and Margo will now come back and give us some advice about best practices for how to understand these future constitutional amendments that will be on our ballot. So, Margo, would you like to put your slides up? Thank you.
Yes, and Joan, just before I get to the best practices, because it will tie in, I wanted to make sure Dennis had time for his part, but I do want to add the historical background on the bail amendments. The historical background for the bail amendments was the Waukesha Christmas Parade tragedy. And before that had occurred, there had been a pretty good movement to eliminate cash bail completely. Many courts and counties were using a risk assessment tool, like a form that you could fill out with, how many prior convictions someone had, what their risk factors were for future conduct, their income status, things like that a judge could take into account for setting bail. And the Waukesha Christmas Parade, which was indeed a tragedy, but one man in that instance changed really the trajectory of our state's consideration of bail. And all of the efforts to eliminate cash bail ended, and the legislature was pretty quick to pass this amendment in 2 consecutive legislatures to get it in front of voters for the bail amendment. So that's the background of that, and it's I will touch on that again too when I get to kind of the best practices. So I'm going to share my slides again. So this is the Wisconsin Constitution. It's a copy that is in the rotunda at the Capitol. If anybody wants to go see it, it's behind glass. And you can go look at your Constitution if you so desire.
Can you put your slides up, please?
Am I not sharing?
Yes, you are.
Okay.
I only see the previous speaker's slides.
Oh, that's strange. Does anybody else not see general rules for voters?
I see Margo's
I
slides.
okay.
I see Margo's slides.
I
yes.
see it. I
Yep,
see
now
it.
I do. Thank
Okay.
you.
Thank
Okay.
you.
Okay. So general rules for voters. General things to keep in mind anytime you see a constitutional amendment. And Joan talked about one that will be on the November 2026 ballot. And that is one that seeks to bar any kind of order directing the closing of places of worship for a health emergency. But anytime that a constitutional amendment comes up, these are things to think about. The first one is don't just read the question. Take the time in advance to read the actual amendment. The question gives you the gist of an amendment, but the actual amendment is not actually presented to voters. You have to go find it. And the legislature is not required to explain the amendment at all. So my organization back in late 2019 challenged the Marsy's Law ballot question as misleading voters and not fully and fairly informing voters about what they were really asked to approve. And my organization won at the trial court level, but we lost in 2023 in the Wisconsin Supreme Court. And the court at that time not only said that the question does not even have to fully and fairly inform voters, they actually said that the legislature doesn't have to tell you much about the question at all. And in fact, two of the justices, Hagedorn and Rebecca Bradley, said that the legislature could just say, do you vote in favor of the amendment? And they don't even have to explain what the amendment is. But Hagedorn wrote that the Constitution's provision regarding amendments, and this is the quote, does not require any substantive discussion of the amendment in the ballot question submitted to the people. No explanation or summary is constitutionally commanded. And then he continued that a ballot question is only deficient, and quote unquote, in the rare circumstance that the question is fundamentally counterfactual so that voters were not asked to approve the actual amendment. So the question has to be opposite of what the amendment is to be in violation of the responsibilities of the legislature to inform the public, the voters, of what the question is. Rebecca Bradley wrote a concurrence, and she said the court's test regarding constitutional amendments boils down to, quote unquote, did the ballot question contain clearly false information? So only if the legislature is telling you something false will the question itself be invalid. She said that, quote unquote, the constitutional purpose of a ballot question is not to educate voters. Voters are trusted to inform themselves. So going back to what I first said, don't just read the question. Don't expect the question is going to tell you exactly what the amendment does. The question, expect it to be confusing, possibly misleading, and expect it to require some good amount of thinking about what does it really mean. The website Ballotpedia ranks questions regarding reading and understanding the grade level, and our questions are often graded at a college reading level. So don't expect the question to tell you what it really means. Next, know that constitutional amendment referendum questions are framed and worded for a yes, and that's by law. The question, a yes vote means voters pass it, a no vote means they don't. So it's going to be framed for a yes. And know that the legislature wants you to pass this. So they've passed it twice, and they want you to pass what they've passed. It's going to be framed for a yes. And I saw some comments in the chat about the Legislative Reference Bureau does write the question, but the second time that the amendment goes through the legislature has to put forth the question in the joint resolution for passage that time. So if the legislature doesn't agree with what the LRB wrote, they can ask for a different question, is my guess, because the legislature is the entity that's putting the question into the resolution that will then go to the people. The legislature wants you to pass it. They're going to frame it for a yes answer. You're going to want to say yes. And then look for other reasons why this question is on the ballot. Is this an attempt to get around the governor when the legislature and governor are not of the same party? And Doug referred to a couple things that should be or would be better as statutes, not in the Constitution. Why do we want very, very specific provisions in the Constitution that are better suited for statutes? Well, one of those reasons may be that the legislature and the governor do not agree. So the legislature cannot get legislation passed. So sometimes the Governor Evers has vetoed things that may end up again in questions for ballot questions for constitutional amendments. And why is that? It's an attempt to get around the governor. And that could be true if the parties were reversed. I'm not saying that it's only a Republican legislature and a Democratic governor. The roles could be reversed, and it could be the same instance. So for any constitutional amendment ballot question, consider whether this is something that the governor has vetoed, and that would be better as a statute if the legislature and governor were of the same party. And is that the reason it's being sent to voters? Again, is this something to cement something into law in case control of the legislature or Supreme Court changes? So as Doug alluded to, it's, you put something in the Constitution and then it takes away from the Supreme Court any decision or argument that this violates the state constitution. It's in there. So the legislature can try to cement something in place in case the court flips, in case the legislature flips, and could just repeal a statute. Another question is this an effort by the legislature to draw voters to the polls in certain elections? So by focusing on attention-grabbing issues, the proposed amendment may cause certain people to be sure to vote. And this is probably true for the November 2026 election, with a question that's already on the ballot, preventing the closures of churches during states of emergency. When we have an election coming up in April 2026, why did the legislature pick this question for November 2026, skipping the April election? And so be skeptical about why it's on a certain ballot, why it's on a certain election, what is really the purpose behind it. Another question to ask, is this a problem that really needs fixing, or is there some other reason for the amendment? And that's regardless of who controls the legislature or the governor position. So for instance, as I said before about the background for the bail amendments, was there really a problem that needed fixing? The Waukesha Christmas Parade failures in that case were because the prosecutor, defense attorney, court didn't have the information that was out there that had been created regarding that particular person's risk of committing future crimes. It was a human error, not a system error. But for that particular event, the legislators could say, we're taking action. They could tell their voters, we're taking action. We need to, change bail, and here's how we're doing it. There wasn't, as far as I ever saw, any kind of research done about whether this change would improve public safety. It was more of a reaction to one event rather than really identifying the basics of why that particular person was let out in error. And then should the Constitution be filled with provisions that belong in statutes? We're junking up our Constitution by putting in so many very, very specific things that down the road may be bad policy and will be very difficult to undo. So be critical, be skeptical, do your preparation in advance, question why this is on the ballot. And with all that in mind, if you don't understand a question and are in the voting booth, perhaps say, either don't vote on it or vote no. If you don't know what it means, do you really want to be changing the Constitution to do something that you're not really sure that you want it to do? I have a couple examples of misleading questions. So one of them was the bail amendment that I talked about before, where voters were asked whether the Constitution should be amended to impose conditions to protect the community from serious harm. Doesn't that sound kind of like a no-brainer? Sure. I want to say yes to that. It did not tell the voters that the change was being made from serious bodily harm to serious harm. That could just include property damage of $2,500. The public was not like clued into how far this could go in creating the ability to put conditions on someone. It's a grade level 14 reading level per Ballotpedia. In 2020, this is the Marsy's Law election. Shall Section 9M of the Constitution, which gives certain rights to crime victims, be amended to give crime victims additional rights? Sure, doesn't that sound like a good idea? It failed to tell voters what particular rights were being added, and most importantly, it failed to tell the voters that certain state constitutional rights of an accused were actually being deleted. The right to a fair trial under the Wisconsin Constitution was deleted. That was a grade level 13 per Ballotpedia. So just the ability for your average voter to understand it is difficult to begin with, and you're being possibly misled by the language of that the question, because it doesn't give you the full information about everything that amendment does.
Hey, well, thank you very much. I appreciate it. Okay, we are at 8:30, and there are lots of questions in the chat. So if you need to leave, please do. Otherwise, Mara Enlow is been monitoring the chat, and she is going to focus on some of the questions that have been answered. Also, if you've been reading the chat while this is going on, our speakers have been answering other questions as well. Some of the questions have already been answered. Myra is a member of our Impartial Justice Committee. Take the floor, please, Myra. Thank you. You're muted. You're still muted. Myra.
Sorry about that. Yeah.
That's okay.
Yeah, a lot of the questions have been answered in the chat as the presentations have been going on. One of the questions comes from Jane, and she's asking Margo, is it clear how the bail amendment is playing out? It feels like a debtor's prison where people can lose their jobs, their homes, their families before it's even known if they're guilty. And I think that question probably came in before Dennis gave his presentation, which made it pretty clear that that's the case. There were a lot of conversation. There was a lot of conversation around who interprets these constitutional amendments. I think those questions were answered by Doug. Jane is asking Dennis if at the Joint Finance Committee meetings about the biennial budget, it's common to hear county officials asking for more money for both public prosecutors and defenders. It seems like money is allocated more often for public prosecutors and less often for public defenders. Does that mean more people are stuck in pretrial incarceration? Dennis, do you want to take that question?
Yes, I'll take that question. That is absolutely the case. It has been times where individuals are sitting in pretrial and the public defender's office is so backed up that they don't even have an attorney. They won't even have an attorney. And I've witnessed that, with my own eyes. It's just individuals, it's caseloads is just so inundated. You either have a situation where you have to try to come up with some money to get an attorney, which at some point would be nonsensical because you would try to use that money to get out, or you just sit there and wait to be able to have an attorney afforded to you, and it's just absolutely absurd.
Thank you. Okay. Any more questions, Myra? I think
Thank
there
you.
were a lot of questions.
Yeah, Janie asks, are there statistics being kept on how many people are being negatively impacted by the bail amendment? Do you know that, Margo?
I don't know offhand, comparing now to before the amendment, and measuring that. I'm not sure if Dennis may have some of that information.
I don't have it right in front of me now, but it is something that EXPO does track, but I just don't have that information with me now.
Okay, well, that's good to know. Thank you. And then Janie asks, is it too late now to add a provision for risk assessment and determining bail provisions?
Well, it's too late to put it in the Constitution. You'd have to get the legislature to pass, another amendment for that. But the legislature could pass a statute for that. And the risk assessment tool that I talked about before, some of the counties are still using it. It's just that judges have much more ability to impose conditions, impose bail now than they did before. But the risk assessment tools that have been used that measure, a person's background and try to estimate the likelihood of, some public harm can still be used. And it's, of course, it's very, very imprecise. It's very hard to predict who may, cause no problems whatsoever if released, and those people sit in jail because they can't pay, versus people who might commit some other crime while they're released. It's, very difficult to predict that.
Thank you. Melanie is asking, Margo in particular, if your slides will be made available so we can especially reference the best practices.
Sure.
Yeah.
Joan's got a copy of them, and I can, forward them to anybody who wants them. I don't know, Joan, if you'll send them out to anybody, or just let me know. You can put your name in the chat, and I can email them to you. I'm happy to share them.
And Melanie will be.
The entire recording will be provided to everybody who is registered, so they'll have all of it. They'll have all the information.
And then finally, Richard asks, what sort of changes would cause the DA's office to ask for bail requirements in the first place? I'm guessing speeding or shoplifting might not trigger that kind of obstacle, but what would?
Dennis, you want to take that one?
Well, it's kind of to say that speeding and shoplifting wouldn't. It absolutely could, depending on the judge being able to say, well, a person has a background in reckless driving or shoplifting. So it definitely could be a situation where a crime as small as that on its face could still be, especially if it can be connected to a pattern of behaviors, can definitely ask for a higher bond in that situation.
Yes, because that's where the totality of circumstances comes in. That's right. They look at the whole record of the defendant earlier.
Absolutely.
Yeah, Myra, there was a question I saw a couple of people asking about whether the ban on non-citizen voting had anything to do with local elections. And so
Yeah.
Go ahead, Myra.
Yeah, those questions were answered in the chat by Jasleen, but if Jasleen, if you want to comment a little further on that, we could take a few minutes.
Jasleen had to get off for the evening.
Okay.
Okay.
Yeah, no, I think she answered those questions basically saying that because Wisconsin doesn't currently allow non-citizens to vote in local elections, it's not impacting practice here. But I think it's true that because it's now in the Constitution, it would be very difficult for local communities to allow non-citizens to vote.
Yeah, if I could just jump in real quickly on that issue, that was absolutely, and I think Jasleen mentioned this, that was a messaging thing. So there was this specter raised by the proponents of the amendment that, well, if we don't do this, then local clerks might very well allow non-citizens to vote. Again, it was a non-issue. It wasn't happening, but this was a messaging thing by the proponents of the amendment. Really anti-immigrant. That's essentially what it was.
Yeah.
And other states do allow non-citizens to vote in local elections for their school board and so on. And I think the legislature here was very afraid that that was going to be coming to Wisconsin, and so they put the amendment in. And
Or at least they said they were very afraid, yes.
yes, they said they were very, very good point, Doug. Are there any other questions, Myra, that we haven't addressed?
I think that covers it.
Okay. Well, I really appreciate it. I'm sorry that we've gone over 10 minutes. I just close with a couple of comments that as an organization to safeguarding democracy and protecting the rights of every voter in Wisconsin, the League is raising its voice to protect our Constitution and good governance of our state. We appreciate that your lives are really busy, and we're glad that you've taken the time to listen to our speakers on this very important issue of understanding how constitutional amendments need to be limited to amendments that improve our state governments, our state governance. Thank you. Thank you very much for attending. Good night.